啱好。
Members, we have got more than 6 members, and it's the appointed time to start. Please invite the officials to join us.
大家應該收到好多。
Members should have received a number of papers. Some are from the sector, and some letters were sent to me, and I thought they should be circulated. And also there are papers from the administration. The sector's views are diverse, and the administration have considered such views. And members may wish to take them into account in taking matters forward. Last time, a suggestion was made that this blue bill should be withdrawn. So let's look at those questions and answers before we consider that. And also, let's work out the meeting schedule for the following week. I don't think we can make it within this legislative session. And the items for the council meeting on the 9th of July have all been slotted. So, welcome. Deputy Secretary, over to you for a brief introduction. You may wish to highlight some of the concerns raised by the trade and members last time. Thank you, Chairman. I'll briefly refer members to the views and concerns expressed by deputations and individuals. Actually, our views have been set out in the paper. And there are certain views expressed. For example, there were some suggestions about establishing a statutory body to take over the PBB. We believe this should be the subject matter of different exercise. There's another steering group subcommittee looking at manpower. So there's the subgroup, the pharmacist subgroup should be able to take into this matter. Second matter raised was code of practice or code of conduct. And the PBB, many people ask for more representation on the board. Actually, at present, there are 2 members who are qualified in pharmacy or pharmacology, each of whom is teaching at or nominated by the 2 universities, Hong Kong U and CUHK. And there are also 3 registered pharmacists nominated by the industry. So the 5 members are already qualified pharmacists in respect of the membership of the PPB. As for qualification of authorized persons, we have consulted the relevant stakeholders, and we've set out the qualifications recognized. We have made a count. We have counted the numbers. We've talked to 40 trade organizations and associations in the preparation of the code of practice or code of conduct. And we have also sent letters to all these organizations and enterprises to invite them to comment on these COPs and COC, including all the wholesalers, retailers and authorized sellers of poisons. All of them, 2,000 of them, have been invited to offer comments. We have offered 12 seminars, and altogether they were attended by 750 representatives. So that's the gist of what we've done in relation to the consultation exercise over the COPs and COC. So there has been wide consultation, and we have invited the trade and stakeholders to offer comments. As regards authorized persons, as we explained last time, we have make reference to the EU system. This is an international practice. So apart from pharmacists, we also include certain qualified people. They should have at least 3 years of experience in the manufacture of pharmaceutical products under the GMP system. So we believe this is well recognized, and we do not think that AP should only be a pharmacist. We can assure members we are not trying to relax the regulation system through this bill. We are aligning ourselves to international practice. The next issue, definition of authorized sellers of poisons. In the past, we referred to business. We used the term business. In the new definition, we would say that an authorized seller of poisons would include a natural person and a legal person. So it can be either a pharmacist or a company. This is not dissimilar to the present practice. At present, a company and a pharmacist can both be authorized as sellers of poisons. So we are just proposing a textual change in the amendment. And there's the concern about the the validity of the clinical trial certificate and the certificate of test. Two relevant trade organizations have written to us to give their support of and they think that since the procedure is complicated, the validity period of 2 years is too short. So we would amend this provision to make it valid for no more than 5 years. We want to establish a record system so that we can do tracing of pharmaceutical products and to ensure safety. And having written records also help us tackle illegal sale of pharmaceutical products. Because if the retailers do not keep any written records, they may try to shirk their responsibility by saying that they were sold unlawful products by certain unscrupulous wholesalers. We accept different forms of records, including the email, fax, and other electronic communication. And we are going to do this in phases. First of all, we cover the poisons. That's all I want to say. We're happy to take questions. Deputy Secretary, this paper and some papers issued previously have referred to the concerns of the trade. Regarding A, well, members, you have to pay attention to this bill. It's about pharmaceutical products. But you may wish to discuss the 6 points as views and concerns expressed. And then we can come back to A. I'm sorry, I'm late. Paper number, please. It's 1735/1314 02 rather. So it's administration's response to issues raised by deputations and individuals. So let's have the first round, 5 minutes each. Dr. Kwok-Kake. I don't agree that the paper be withdrawn, because we have waited for so long for some legislative amendments to better protect the interests of patients. I have said that the proposed amendments are not good enough, are not sufficient. For example, selling of poisons and dangerous pharmaceutical products should only be conducted in the presence of a registered pharmacist, and this is not yet implemented. I agree that we should refer to the request and aspiration of the trade first. Pharmacists working in pharmacies are having a lot of grievances against the regulator. So I think the regulatory mechanism should be updated as soon as possible. I agree that this is not covered by the bill, but the government should promise as regards when the regulatory system can be changed. And then there were some later letters representing certain associations of pharmaceutical research institutions and universities, as well as patients' associations. They all agree that we should do something quickly. Let's first of all clarify a point here. We are not doing this not to please the trade. No one wants to be monitored and regulated. We cannot say that the whole package of proposals should be withdrawn just because they are not complete in our views. Apart from research and research institutions, there are also the unions representing pharmacists. Have they indicated their position, whether they support this or not? In particular, have we asked pharmacists working in hospitals? And I agree that order of pharmaceutical products should be made in writing, but they are going to introduce this system in phases. Why? And what are you going to cover first? Email, fax, or would you accept other forms of electronic communication such as WhatsApp? And it's also said that if a registered pharmacist is an employee of an authorized seller of poisons, then the pharmacist is not going to be held liable. So the responsibility is passed on to the authorized seller of poisons. So that's a safeguard afforded to the pharmacist. But if the pharmacist is both an authorized seller of poisons and a pharmacist, would he be then held liable? Please clarify. And also, why do you need to carry out this or propose this technical amendment? What if it is not done? First of all, professional pharmacist views. The chairman must have received a letter from certain organizations such as the Pharmaceutical Society, Hong Kong, or College of Pharmacy Practice, and also Practicing Pharmacists Society of Hong Kong. Dr. Kwok is correct. Some of the deputations commented on authorized seller of poisons. And because in the technical amendment we mentioned pharmacists. Actually, ASP can either be a company or a pharmacist. You can run a company, and the company can be an ASP. So instead of business, we put down the two possibilities. But if no pharmacist is only employed by ASP to manage the sale of the scheduled poisons, then the pharmacist will not be held liable criminally for acts of the ASP. But of course, if the pharmacist is also an ASP, then he will be held liable because he's an ASP. As for placing the written records for purchase of drugs, I would ask my colleague to explain why we want to cover important drugs first. Well, the phased introduction is a risk-based approach. We'll cover antibiotics and dangerous drugs first. Some are non-poison, some are non-part 2, some are part 2 poisons. And they will be covered in the next phase. They will not be covered. Why do we need the point 12? Why do you need the technical amendment? What if we don't have it? What would happen?
No, it's merely legal wording, because business is not a legal person. Because a business is not a legal person, so we want to clarify that the business is either the pharmacist or the company. So that's the matter of paragraph 11. So in the future, it must be a person who would be responsible and not a company. It's both. It can be a company, it can be a pharmacist, because a company is also a legal person. So it's the owner or holder of the company. Claudia Mo. Now the Hong Kong Pharmacists Union, they were demonstrating downstairs. There were 6 of them. Now the pharmacists, they are very busy people, but they come to demonstrate and show their placards. Now we need to consider the facts when we consider whether the bill is to be withdrawn. This is a whole page of reporting in the newspapers. If the media thinks that it's meaningless, they would not accord this a whole page. And now the latest letter says that the grievances of the trade is very deep. The members should try to give them justice. And the objective facts are this. The Hong Kong, the Medical Practitioners Union and the Pharmacists Union says that the administration hasn't communicated properly with the pharmacists industry, and they came up with this bill in a hurry. So they asked the administration to withdraw the bill first and then consult effectively with the trade and with the public. Now, I don't know what problem arose. Now, I am not familiar with the sector of medicine and pharmacy, and I do not pretend to be familiar. But if you say we will not withdraw the bill, we've waited for this a long time, we must go ahead. And yet there is such a gulf between yourselves and the trade. Now, they are professionals. They have to be licensed, and this is a matter of life and death. There must be a proper discussion first. Why is it that when the third reading is approaching and yet the Doctors Union and the Farmers Union both ask you to withdraw first and rethink the matter? Now, what happened? Now, you shouldn't just go ahead willy-nilly. You pretend to be ready to discuss, and yet you do not listen to people's views. And this is the case also for the Radio Hong Kong and the universal suffrage. And now this is a bill that has to do with life, human lives, and you still insist with this regard to the trade. Can you tell us about the history? Is it something born out of nothing? Now, please look at the document. No, I'm not asking about history. I'm asking about the news. Now, I'm sure you must print a bill for some reason, but clearly what you did was not sincere. The government says it's consulting the public for universal suffrage reforms, but it's actually ignoring the public's views. People are aggrieved. I'd like the Deputy Secretary to explain. Is the bill produced surreptitiously? Now, my issue is, why is it that the doctors and the pharmacists are not convinced? You tell him to talk about history? Ms. Mo, I think I have the obligation to let the administration tell us whether this bill is produced for inadequate reasons. Now, if you are unhappy with it, you can tell the administration not to answer, and I will let you have your time again. Now, you do not have to interpret my question. You can be dissatisfied with my words, but members are saying that this blue bill has not been produced after proper consultation. I'm saying that there was problematic consultation. I said I would give you time. I was asking the administration to tell us about the history of consultation. You may not agree with my phrasing. If members have a question, I must ask the administration to inform us about the history of consultation. You may not like the word history. You have 1 minute. Are interrupted after 4 minutes. Please do not waste time. You still have 1 minute. Administration. Let me be brief. I'd like to refer back to the document. On page 4 of the document, it says that the medical sector, the doctors and pharmacists, their unions in 2010, 2013 at the Health Services Panel. They were consulted, and the Hong Kong medical sector, they also supported written orders. Now on the consultation for the code, we've consulted the various trade bodies, including those for dentists, doctors. So now, as for the pharmacists union, well, I'm sorry, they were established in April this year only. They were registered in February, so they were not on the list of bodies consulted, but I didn't want to repeat the figures. We sent over 5,200 letters to the sellers and concerned persons concerning the code of practice and code of conduct. Now I can read that again. That includes the code of practice, code of conduct, ASPs, the listed poison sellers, LSP, and licensed importers, wholesalers. We have over 700 bodies that sat on these forums, and there were over 40 organizations on as listed in the document of 16th May. So we did broadly consult the sector, but as I said last time, it's a matter of regulation, so certain members of the sector, of course, responded differently to the regulation. Now, on the background, in 2009, now the authorized person doesn't have to be a pharmacist. Now, you can argue this backward and forward, but they are not convinced. They say that they are a newly established body. Because they are new, they do not have to be accorded attention. So they were scared by this. That's why they were established. I give up this dialogue. ASP is European Union international standard. The authorized person is defined according to internationally accepted practice. Now, for the we've written to the APs, and they have supported this. They have written to the Bills Committee, voicing their support. You have 30 seconds, Ms. Mo. I give up. Mr. Albert Chen. Now, I'm not too familiar with this subject matter, I must confess. Now, of course, anything that has to do with public interest is of concern to me. Now, I do not want the administration to act as if this is a juxtaposition of the different interests of patients, pharmacists, or whatever groups. The affected bodies must feel that this is reasonable. People must be convinced. Now, at this stage, I well understand that Ms. Chair has consulted intensively, and she has done a lot of work. It's like Mrs. Carrie Lam, she has consulted broadly, but she is actually doing the bidding of the Beijing authorities.
So, the question is it fair to the practitioners in the trade. And we have to look at the definition of authorized persons and liabilities, and also the setting up of independent organizations, and whether the practitioners have a reasonable say over what the organizations can do. So there are different issues. I've received submissions from different organizations. I've received one from the Doctors' Union raising objection. So apart from pharmacists associations, I received an objection from another professional body. Well, I was very puzzled already. I was in two minds. I couldn't decide whether we should go for better protection for patients. You said you follow the EU practice. So you give me a reason to look into the merit. It's just like Mrs. Carrie Lam want the council to be authorized to punish legislators, just like the German parliament. But she failed to talk about the democratic system of the parliament. So perhaps you should try to give us more justifications so as to assure members. I understand members' concerns, and I understand because the amendments are technical. Why do we follow the EU practice in setting the definition of the AP? Because the AP is authorized, is licensed to manufacture drugs, and therefore we have to follow the experience of big enterprises manufacturing drugs internationally, and we go for the experience, the requirement on 3 years experience in accordance with GMP. This is an internationally recognized requirement. The pharmacists union is querying why we do not specify only pharmacists can be APs. But we mentioned other important disciplines such as toxicology and so on and so forth, which are also important in the manufacture of drugs. So for AP, you follow the EU, but do you follow the AP for the entire system? If you just follow EU in one regard, would that end up with a biased system whereby the liability is not imposed on the right parties? Well, in Hong Kong, doctors can dispense medicines, but in overseas countries, the pharmacists work independently. But for manufacture of drugs, the drugs can be marketed worldwide. So we must adhere to international standards to ensure quality. So we make reference to international requirement. The AP can either be a pharmacist or someone holding an appropriate qualification, such as those who have 3 years of experience in the manufacture of drugs under the GMP system. The Doctors' Union, Hong Kong Doctors' Union, is against the requirement to order drugs in written form. They have been saying so since the day they became a member of the consultative mechanism. This is the question of balance. We don't see that this would impose an undue burden on the trade. And even for this written purchase requirement, we only cover the drugs in phases. We cover poisons in the first stage. At the status quo is undesirable. You don't have to keep any written records. You don't have to keep any record in fact. So when you want to inspect the records, you don't know whether anyone has purchased any problematic drugs. And even if you want to implement a recall, you cannot trace the drugs because no one is keeping any record. So on balance, we believe that on balance, we think this is worthwhile. We can offer better protection by asking purchase to be made in written form, and we accept different electronic communication modes, email and so forth. It's not very different from placing drug orders through telephone, but we do know that there are divergent views. Mr. Chen has his concerns. I've explained the matter to him repeatedly. I understand that he wants to make it convenient for the trade, but we understand that, and in fact we are only introducing the system in phases. Mr. Leung Yu-chong, I must say that I don't know a lot about the industry, and I certainly hope that my attendance here would allow me to gain a better understanding. I heard the Deputy Secretary last time, and after that I talked to the trade. I will only return to the question of who have been lying. Let's talk about the EU standard. And that is, apart from pharmacists, people with 3 years of experience in GMP drug manufacturer holding a diploma would also qualify. The 3 years experience is required even for pharmacists, but the AP can be a non-pharmacist. I heard it very carefully. You are doing this in accordance with the system of well-established pharmaceutical producers in Europe. But are we having a lot of big pharmaceutical products in Hong Kong which are subject to the same level of regulation in terms of quality assurance? Yes, you follow the EU directive in that pharmacists and some other qualified people can be APs. But those pharmaceutical manufacturers in Europe are subject to stringent regulation for all the processes. Is that true of Hong Kong? Well, because on the face of it, it seems all right that you're right in borrowing the system from EU. And if you allow electronic communication to be used in placing orders, such as WhatsApp can be cleared, and there will be no record. And what about email? How can you dig out past records? So there will still be problems. It looks like a convenient approach, but there are problems with such communication modes. And also, I said I would like to find out who had been lying. You said they were consulted. They said they were not. No, so the point is, you did consult them, but what you consulted them over were not the same as what we are seeing in the Blue Bill. For example, the definition of pharmaceutical products and so on and so forth. Did you tell them? Did you tell them what the bill will be covered? Did you consult them over matters which are not covered, which are not mentioned here? So you are acting in accordance with the report. You are acting on 10 odd recommendation out of 70 odd. Have the views been fully reflected? Have you tried to take on board all their views? A yes or no answer will suffice. So there are 4 issues. So you are saying that it's the EU's practice that an AP is not necessarily a pharmacist. But the question is, are we adhering to EU standards in the entire process of pharmaceutical manufacturing, and also the use of electronic mode of transport or communication in placing orders? What if no tracing can be done afterwards? Well, we opt for EU standards. The 24 drug manufacturers in Hong Kong are all in compliance with GMP. But what about the smaller ones? Well, we expect them to be involved in packaging only. Well, that's what you expect. Well, they have to do this, otherwise quality cannot be assured. Let's say we have 24 major, big, established manufacturers. Are they living or complying with a GMP? After the discovery of moldy drugs, all drug manufacturers have to comply with GMP standards. The smaller ones will only be doing packaging. Well, in the future, we are going to go for pigs. Sorry, I don't think you should be talking in a direct dialogue. I think Mr. Leung Yu-chung has made a point. There are big and small drug manufacturers. If we are talking about EU standards, is it true that only big manufacturers are in compliance with EU standards and smaller ones are not? A few years ago, since the moldy drugs incident, has the DOH imposed a uniform standard among the drug manufacturers, big and small? If you manufacture drugs from ingredients, you must have GMP. The smaller ones do not have to get GMP accreditation for the time being. And internationally, everyone is getting GMP accreditation. I have to stress again that allowing someone who is not a pharmacist to be an AP is not a relaxation of requirements. We are talking about university graduates in a related discipline, although they are not pharmacists. And both pharmacists and people holding other qualifications, they have to get 3 years of experience in GMP drug manufacturing before they are qualified as APs. I will ask Ms. Wu to supplement. Well, where are pharmacists required? Community pharmacies or drug manufacturers or drug packaging factories? Only big manufacturers need to get AP, not ASP. Only big drug manufacturers need to be qualified as APs. The pharmacies will only get a license as ASPs. So that's why I say this is complicated. We have manufacturers, we have seller of drugs.
Well, it seems I'm being led. Now you talked about large manufacturers, and then you talked about pharmacists. But I didn't mention pharmacy. I was talking about manufacturer. Now, is it that throughout the entire manufacturing process there is stringent supervision up to international standards? That's what I was asking. I'm not talking about pharmacies. I'm not talking about packaging. I'm talking about the manufacturing process, because you are saying the manufacturing process where non-pharmacists can qualify. Let me try to clarify. Now, all the manufacturers of Western medicine in Hong Kong, now all these 24 manufacturers are GMP manufacturers. They meet very stringent standards on personnel, on space, on record keeping. They follow the GMP module or system, and Hong Kong has joined a PICS as a member, and this is true also of EU, US, Australia, Singapore. They are all PICS members, and so has Hong Kong. So this is an internationally accredited standard for manufacturing of drugs. So it's all GMP standard in Hong Kong. So the 24 major manufacturers qualify, but are there manufacturers outside of the 24? No? Okay. I'm sorry, I have to repeat. In Hong Kong, do all manufacturers of drugs have to follow GMP? So first I'd like to ask, there are only 24? All Hong Kong manufacturers of drugs are GMP, though not the packaging concerns. So they have to be licensed. The packaging ones are outside the 24. Those who do packaging are outside the 24. It depends on how you delineate. Their manufacturing process goes only so far as packaging. The procedures, the processes are different. They also have to be licensed, but they don't have to be GMP. They are not required to be GMP right now, but in the future they have to be partially meeting the GMP qualifications for the processes that they are involved in, because the wholesalers may have imported some products that are packaged in thousands, and they have to be repackaged in 20s. So that's part of the wholesale work process, and we require that those who engage in packaging have to be licensed as manufacturer. Now, these right now do not have to meet GMP standards, but we are going by phases. We are discussing with them, and they are going to meet the PICS requirements. So for this part of the work process, it will be PICS GMP. So they will be licensed and come under your supervision, yes. So these 24 are required to have APs, and that can include non-pharmacists. So how about the packaging manufacturers? We are talking about the manufacturing process that requires AP, or authorized person. Right now, we include pharmacists as well as non-pharmacists who have to be university graduates. It's the 24. The packaging ones also is okay, because if the work processes are simpler, then the requirement is simpler than that of manufacturing out of raw materials. So if it's for the manufacturing part, the pharmacists and non-pharmacists are acceptable. So that's also the case for the packaging concerns. Now, I understand why is it that you will be diversified for the packaging manufacturers. Now, what does the AP do? The AP keeps watch over the manufacturer with regard to the release of the products. I understand that. I have been told that non-pharmacists are allowed for the 24 manufacturers because they have knowledge about microbiology or whatever. But why is it that you are also lenient for the packaging concerns? Because that is not the manufacturing process. In manufacturing process, you need technical input. That I understand. Now, our explanation is that if it's secondary packaging, in the future, that will be raised to a GMP standard, which is a very high standard, and that involves not just the pharmaceutical industry, but other subjects, matters in the industry. You need to maintain a clean environment. You cannot make mistakes in the packaging. Whereas the pharmacist is involved in dispensing drugs. So wherever GMP standard is involved with pharmaceutical products, then we need an AP. This is not just for Hong Kong. This is common internationally because the countries involved have adopted PIC standards, so the license holder has to understand a lot about the process. The drugs, when they are packaged, must not be infected. So you need somebody educated up to university at the university standard. So it's not making it more lenient. WhatsApp is okay, but they have to keep record because you can store email and WhatsApp or written communications. Now, the doctors' union is against written orders because they have to store the paper. But actually, you can scan the email or scan the written materials, and you can store them along with the emails and so on. Now, we did all the consultation for the purpose of amending the legislation. Now, we really consulted about the AP for manufacturing and so on, but on the term business, we did not consult because our legal colleagues felt that there is no legal entity called business, whereas we are actually talking a pharmacist or a company that became licensed as a vendor. So why then include the word business? So that is indeed a technical amendment. So when you ask us whether we consulted on the deletion of a comma or a Royal Society, no, that's a necessary part of the drafting process where it's very difficult to consult everyone. Now, when you consulted the trade, where you in your consultation, what did you miss out? Now, the bill is based on the review committee of 2009, the recommendations of the 79 recommendations, 10 odd recommendations have to be implemented by legislation. Now, after consultation, we learned that there had to be a pharmacist at all times in a pharmacy. Now, we put that in the bill, but the industry was concerned. They expressed their concern in the open hearing, and we withdrew that. And now we require just 2/3 of the time. That was the original arrangement, because we did withdraw that proposal for having a pharmacist all the time. So, and we also work by phases. So written form is now required for the poisons at the moment. So of those 70-odd recommendations, now they were discussed for a long time in 2009, and then there was a business index assessment, and then we further consulted. We asked all members of the industry, and then the codes were discussed in the small group meetings. So everything can be traced back, and we missed out on nothing. And some non-poison retailers, they have to be licensed. So you can buy Panadol at 7-Eleven. Now, there was a proposal that non-poisons selling can have to be licensed too. You can't buy Panadol at 7-Eleven. So after consultation, we withdrew that. But there are core issues that have been broadly consulted, but for safety, we cannot withdraw that despite your opposition.
Mr. Peter Cheung. Well, I'm not a professional in this trade. We received deputations last time. Some were supportive, some were not. Some said there was no consultation. At first I was clear, but the more I listened, the more confused I am. But now I'm clear. I will speak as an ordinary citizen, as a user of the products. Because wherever you stand, you always have some vested interest. So I believe I would speak as a citizen. Of course, there is also interest involved. just as in the past, we look into food incidents. And there was a need to trace the problematic food items. And we have to enable tracing so as to enable a recall. And if that's good for food items, then drugs should also be covered. There's a greater need to cover drugs. And I understand the phased approach. You want to impose the requirement of placing orders in writing for dangerous drugs first. I know this is going to be additional workload for doctors. They may have to hire additional hands to handle drug purchase. But from the perspective of the ordinary people, we want to make sure that we can trace the whereabouts of drugs if there's a problem. And I want to know what categories will be covered. Are all pharmacies and doctors' clinics involved in the dispensing or selling of Part 1 poisons? I want to know if this is additional trouble, additional workload, then to what extent it's going to be shouldered by different parties. And also, I want to know about the consensus that you have built during the consultation. We all know the sticking points, the points of disagreement. But what about the consensus? I want to be assured that the consultation was useful. And there are certain views about the guidelines issued by the PPB. Well, they think that the members are not representative, but they are empowered to make guidelines which are mandatory. And you cannot put everything into the bill, and at the end the board will be very powerful. I'm a social worker. The social worker registration board is very powerful. The board can issue, if the board is empowered to issue a lot of guidelines, and failing to comply would mean that I cannot be registered as a social worker. If that's the case, I would object. And in reviewing the code of practice, will the same consultation process be observed? Because if we allow you to get this enacted, and the power is granted, and they can do a lot of things which we have no control over. So 3 points for clarification. I'll ask Ms. Wu to talk about Part 1 poisons. How many poisons are in Part 1? And are these poisons used by a lot of people generally? We have 19,000 registered medicines. I don't have exact figures, but approximately half belong to the category of poisons. That's a ballpark figure. These drugs cover a lot of uses and area, drugs to treat diabetes, cancer, heart problems, and so on and so forth. So all doctors and hospitals and pharmacies would buy and sell, or would be involved in the dispensing of such drugs. The second question is about consensus. You must have received many letters. For example, some are from patients' associations. I have letters from the 2 universities, from professional pharmaceutical associations, and practicing as pharmacists in hospitals, Pharmaceutical Society, do they share any consensus with you? Placing orders of drugs in written form is one of them. The pharmacists union accuse us of backpedaling by allowing the definition of the AP to be someone who is not a pharmacist. We have provided written replies, and also the liability of pharmacists who are employees. We have clarified in writing again that they are not liable if they are employees. And we are also undertaken to look into other issues that they have raised in this year. The doctors' union have raised objection to the requirement to place order in writing. We have responded by saying that this will be done in phases. And I know that the pharmaceutical manufacturers would always issue a written invoice. They don't like return drugs because if you are the manufacturer, would you dare to resell the return medicine? They use a form. It's just like an order form. You can just put a tick on the form. So the sellers, the manufacturers can certainly make adjustments, and the inconvenience cost will be minimized. And we don't think that would add to a lot of additional costs. Mrs. Zhang, you mentioned whether the PPP will be too powerful by allowing to issue guidelines. Well, among the members, 5 are pharmacists. The chairman is the director of health. And there are other people, doctors, vets, drug manufacturers, and lay people. So the board is comprised in such a way that pharmacists are given a voice. This is the first time they said they're going to formulate code of practice. They have set up a working group to take everyone on board. If you are a licensed drug manufacturer, you are invited to be represented. And I believe in the future, when they want to change the code of practice, they will certainly do consultation, because there are always someone from your sector sitting on the board. You may ask, why do we go for code of practice or code of conduct instead of putting it in the law? Well, there are so many of them. We have different guidelines for the sellers, manufacturers, sellers of Part 1 poison, manufacturer of Part 1 or Part 2 poisons, and doctors as people who dispense drugs. So we don't want to be inflexible, and so that the code of practice or code of conduct can be kept up to date. Ms. Alice Beck, I share the views expressed by Mr. Peter Jiang. Last time we had some deputations, and we have been receiving letters, and the government has been providing their responses. It seems that they are all telling us their side of the story. They are talking at a cross purpose. As members, I wonder whether I should be the arbiter or umpire in a match. But I think as members here, I should consider public interest first. And that is, if the bill is passed into law, will there be benefits for the public? So, Deputy Secretary, tell us, well, the bill is supported by someone in the relevant trades. Of course, we cannot go for a referendum. People have been advocating referenda for different issues. I think this is a quote-unquote controversial bill. What are the benefits to the public if this is passed into law? The bill is passed into law. My concern is that even with this bill enacted, we're not going to resolve the problems. Dispensing the wrong drugs will not be a thing of the past, and there are people who are inconvenienced, and the general public may have to pay a higher price for drugs because you require the different parties to do so many things. Ms. Beck, you've asked some pertinent questions. So what's the point of doing all these things? I have to admit that we cannot convince everyone. There are bound to be people who have reservation about some parts of the bill. But what are we doing this for? It is because of the drug incident in 2009, reflecting the problems in the manufacturing, distribution, and dispensing of drugs. There are loopholes. There are 16 recommendations for legislative amendments. Now, that's a result of the reflection at the time in the light of the incident. And that's why we want to prevent damage to public interest occurring again. The Patients Association and the SOCO have written in. They are very concerned. They have looked into the proposals to enhance safety on the use of drugs and on patients' rights. There should not be any big difference. If we ask the placing of orders to be done in writing instead of through the phone, because it provides so much more certainty. If you place an order through telephone, you may mispronounce the word, you may miss the ending S, and it will make all the difference. And we also ask the licensee to be experienced in the manufacturing of drugs. So in the long run, this is going to enhance safety. So I have to stress again that what we are proposing is to enhance safety for the public, because we know there were loopholes. And if we do not plug those loopholes, we don't know when they would come back. And then the question people would raise would say, why didn't we do anything about it? Well, I just spent a lot of time in reading the papers, both the Chinese and English version, during the filibuster. Of course, even I tried very hard. I could only gain a little bit of understanding of the tray. Why do you think that the relevant tray is so has raised so strong an objection to the placing of orders in writing? Well, we don't know, because using your fax machine or email to order your drugs is not a very troublesome procedure, and the drug manufacturers are willing to issue the order forms.
Now, the Medical Society and the Doctors Union. Now, the Medical Union says that all along we have supported the written records, the use of written records. So. I think this should be part of the code, And if you ask the public, they will tell you that when people place orders, the orders have to be placed in writing. So why not for drugs? So we try to alleviate their concerns, so we do it by phases. The poisons will be subject to the new rules first, and when this is done, we can enforce the law more easily when we detect discrepancies between the orders and the actual quantities. Then we can trace it and ask questions. Right now, there are no records. So some people say that you can get certain drugs without prescriptions, and we're trying to prevent that. Can I continue? I'd like to make one point here. Now, written orders, now that was discussed in the subcommittee last year, and so I'd like to ask the Deputy Secretary, can a colleague of yours explain what is a written order? Is it between hospital and manufacturer, or between pharmacies? So written orders may mean different things. Where does written order occur most? Perhaps Ms. Ng can start. Who in the industry would employ written orders? Now, people purchase drugs from suppliers, right? So it would be the wholesalers that sell drugs, and who would buy from them is the doctors, the pharmacies. So these people have to buy drugs, so they have to place orders. So a doctor may want a medicine to lower blood pressure, so he finds a GSK or manufacturer, then right now they say they merely phone the manufacturer, but even though the medical society say they recommend written orders, and the suppliers have a delivery form. So when the doctor places the order by phone, then he can send an email to the salesperson saying that he wants 10 bottles of medicine for lowering blood pressure. He can fax the order, and he will hand the fax order to the nurse. The order will be faxed to the manufacturer. Same for the pharmacy. The pharmacy buys many drugs, so the pharmacy deals with the suppliers. So after placing an order by phone, or after the salesperson arrives, he would take on the order forms. So there can be an email also. So these would be the written orders. So doctors and pharmacies are the parties who use written order most often, whereas a member of the public would need a doctor's prescription to buy drugs. I think it's the doctors who object most strongly, because for wholesaler selling to pharmacies, very often it's already in written form already, because a pharmacy that sells poisons has to keep a written record anyway. So the drug incident occurred in the doctor's office. Now, the order was made verbally, and there was a written delivery form, but the delivery form does not have to be kept, so there was no written record at all, and that leaves a loophole, a gap. So no pharmacy was against written order in our consultation process. No manufacturer, no wholesaler objected, because that has been the practice. But if we leave out this part, then it's the patients that would be most vulnerable, because very often they consume the drugs that are in what we call loose packaging, that is in granules or pieces, and that's vulnerable to errors. Now, it seems that some doctors are in support of written orders, but other doctors are against it. Are there pharmacists against this? Now, we know that it's only the pharmacists union that's against written orders. In CP2 1735-1314, now you listed 7 issues. Now, the first issue, we said that we would not discuss that. Are there others where some people are for and some are against? So we want to know, because we want to know whether most people are against it. Now, this is a document that you should have. Now, apart from the first topic, on the other 6, can we know the balance of support and versus opposition? So we need to know how to address their concerns. Now, if the bill is indeed so controversial, if the trade is so strongly against it, then maybe we should not let it pass. But we want to find out if that's indeed the case. Now, on 4th of June, there was a jointly signed document. It included, one of these signing parties was the Hong Kong Pharmaceutical Society of Hong Kong. There was a Society of Hospital Pharmacists, and there was a College of Pharmacists Practice. Now, all these are institutions of a long history. Now, these 3 societies have 700 pharmacist members. They have written to voice their support, and in the letter of 4th of June, they said that these are recommendations of the 209 Review Committee, and they accept all the recommendations with the exception of a few technical amendments. So the letter of 4th of June voiced the support. So where we were amiss is that after the consultation, some people continue to object. Now, the doctors' union were against written orders even in 2009. The other societies have been in support. And most members of the review committee, including those of the pharmaceutical institutions, were in support. So I know roughly what you mean by written order. I was confused after the last hearing. I asked some doctor friends, and it's rather strange. Now the doctor friends, especially those working for HA, say that has been the long-standing practice. So why is it that they are so strongly against this? Maybe the Deputy Secretary cannot guess why they are opposed. So I'd like to ask, when written orders are employed, what are the benefits for law enforcement and for patients? I think law enforcement is the most important, because if law enforcement is sound, it's a safeguard for the patient's safety. And the Department of Health conducts inspections to see whether drugs are possessed. For instance, psychotropic drugs, which are often subject to abuse. Now, if when we go on inspection and there is no written record of how much has been ordered versus how much is in possession. For instance, the manufacturer says they have supplied 100 pallets, whereas the pharmacy says that we haven't received them, and we cannot prove that the order has been placed. And the defense can be that the person who signed is not one of our staff. But if we have a written record, then it can be shown that the doctor has not placed the order. And if we find the drug whereas the doctor has not ordered the drug, then of course that is an infringement against the code. So that makes it easier for law enforcement. Now, where a mistake can occur is that often drugs sound similar, especially in English pronunciation, and also because the mention of the 0.5 milligram or 0.05, that can make a big difference. So that can often cause mistakes. So when there is a written record, then the delivery can be checked against the order, and this will be a big protection for the patients. And indeed, many people ask, why do you argue? Because this has been the practice. Because email is very convenient. You send it by email overnight and you get a confirmation the next day. Especially for the large-scale procurements, it's a central procurement arrangement, then normally that would be in written form. Now, we are disappointed that consensus cannot be agreed on this. Now, it's the Department of Health that does the inspection and enforcement. Now, were there cases where they could not get hold of the order document and then encounter difficulty in enforcement? You can supply that later. Right now, we do not have such records because it's not required. Now, were you unable to prosecute because you could not get such evidence?
Mr. Leung Yu-chung, well, I've talked to people in the trade a number of times. They are not against this absolutely. they do see the protection that can be enhanced. I wonder if I may assist by offering this suggestion. Well, we have so many meetings packed into the remaining time of the legislative session. So my guess is that it would be difficult to get this bill passed before the end of the legislative session. Last time, many deputations came. Many of them work in large organizations and universities, or they accuse you of lack of consultation, or they were consulted over different matters from what we see in the bill. It's not as simple as changing the words or doing away with the term business. So would you be willing to do more by way of more consultation, especially those deputations with strong views? I believe our Secretariat has got a full list of the deputations. So maybe you should consult them to see whether you can seek some middle ground among members. We are all lay people, apart from Dr. K.K. Kwok and Dr. Leung Ka-lau, and of course, Chairman. We cannot really tell who is right and who is wrong. But we all understand that this has to do with the with public interest, and the implications of getting this law passed can be far-reaching. I'm not asking you to withdraw the bill, but can you somehow make use of the time available to try to gain some consensus or to do more consultation? Thank you, Mr. Leung. Although I'm an optimistic person, although you say that it's impossible to enact the bill within this session, the chairman have read all the pages. Well, if we do the cross by cross, it's actually a lot of too much ground to cover, but because a lot of amendments are about the drugs. As long as we can complete our cross by cross scrutiny before the middle part of this month, although the chances may be considered low, but I would say let's push ahead with full steam, and it's still possible. As regards doing the consultation again, we did one in December, another one in May, and there were 2 or 3 sessions of the Bills Committee. We have met all the deputations, and as soon as the Pharmacists Union, Hong Kong Pharmacists Union was set up, we asked for a meeting, and they only gave us a meeting date of the 20th of June. And even if this is completed before 9th of July, we will only be able to go to a full council meeting in October. If we have to do another consultation, the time frame will be pushed back to the following year. We have been criticized for causing a lot of delay. Mr. Leung, I'm also disappointed. We have carried out a lot of consultation work. I don't think that more consultation would change people's mind with, for example, Hong Kong Doctors' Unions or opposition to the requirement to place the requirement of placing drug orders in written form. Well, I'm not saying that you can. I expect all problems to be resolved if you do another round of consultation. And I am not saying that I expect the progress to be very slow. But if you consider the public hearing, you can see that there were controversial issues. They accuse you of lack of consultation or consultation over different issues from what we have in the bill. It's always good to clarify things. It's already the 10th of June. So what's the problem of consultation and another round of consultation? Well, we all want to work hard, but we don't have a lot of time slots. 2 or more meetings might be what we can manage in the remaining time. So you may subjectively want to see it done, but objectively there's a limit as to what can be done. And we don't need to reconvene the Bills Committee. It would just be a deferral of just one summer break. So why don't you do it as a last attempt in trying to resolve problems? With regard to the views expressed by the deputations and individuals, well, we have tallied the count, the views. I think most of them are talking about the establishment of an independent authority. That's not related to the bill. And there are colleagues from the Hong Kong University who spoke at the public hearing, subsequently wrote in to express their support of the bill. The professional bodies have views about setting up an independent authority to regulate pharmacists. If we are to do the consultation again, it would mean a long delay. We have written to a number of professional bodies. There was a joint submission from 7 bodies, and we have also liaised with a lot of patients' associations. We did call some professional bodies and patients' associations and to inquire whether they would need more briefing sessions. But as I said, the Hong Kong Pharmacists Unions can only meet us on the 20th of June. With regard to the proposal made by Mr. Leung, although we still have 10 more days before the 20th of June, I don't know what arrangement can be made by the chairman. In the past 2 to 3 weeks, I have to attend 2 or 3 concurrent meetings at any one time. Well, of course, we can be present for a brief time, and then away we go. But it's difficult to try to build consensus like this. And I've counted the numbers. Basically, we're talking about a delay of 4 months. And then 6 months down the road, it will be passed. And I'm talking about November, at most December. We would reconvene in October. So at most, it would take us up to December to get everything completed. And Chairman, if you want to convene more meetings, you would expect that a quorum will be formed, but barely so. And then you will give people the impression that we want to go for speed. Maybe we discuss the bill very intensely, but the impression given to people is that we are doing a sloppy job and in rushing things through. Well, if we say that something untoward may happen in the interim, well, but this has been dragging on since 2009. And of course, if there's any responsibility to show that, it will be shared by members and the government. But I think instead we can try to clear away the issues in the summer break period. The Deputy Secretary might have given us the impression that whatever can be done has been done. People have been talking about issues not in the bill but related to the bill. I think it would be best if the summer break can be made use of to clear away the problems with the stakeholders. I'm not going to against convening more meetings, but I also want to do it quickly. But I'm just worried about the implications of doing this quickly. I don't know whether we have missed anything, something which has been missed equally by the administration. And then afterwards, people may accuse us of doing it too fast. And so we have to give careful thought to the implications. So that's what I'm trying to say. I'm not going to oppose any effort to push ahead with it, but I would also say that it would be a much better arrangement if we defer this for 4 to 6 months. All right, I think I should pause here. We were talking about the responses, the administration's response to issues raised by deputations and individuals, points A to G, and we have had a discussion on the views expressed and also the response from the administration. 6:15 is fast approaching. Shall we convene another meeting? Some members are saying that we should put it on hold, and then the administration can do its job to consult them. But we really don't have the responsibility to do things quickly. As chairman, my duty is to make sure that we do a thorough job. We are not trying to adjust speed in the light of trade sentiment or views. We note that there are divergent views, some pros, some cons, whether some are louder than the other. Perhaps we can have a table of the associations which are in support to the greatest extent, which are in opposition to the greatest extent, and then members would note the views, and then we all may come to the realization that the controversial issues cannot be resolved at this stage.
Because some people might still oppose the written orders. Now, maybe we can try to arrange for another meeting. Now, I don't know if there are further questions on the 6 topics. Maybe they're going to give us the same answers anyway. So I suggest that we have another meeting, maybe the 17th, or if that's not possible, a later date. Now, the administration might meet with the union on the 20th of June. That's not our concern. Now, on the item A of CB2 1735-13 to 14 Record 02, that's not part of the subject of the bill, so we do not have to discuss this. We understand that they would have a steering committee report on that, so the controversial items are the items B to G, and we will discuss that when we come to the bill itself. So I suggest that we can go into clause-by-clause scrutiny. Of course, the Council will take up all the time slots. Maybe we won't have any meeting, and we go into clause-by-clause scrutiny. Then there may be technical amendments that can be passed, but there might be controversial issues. Say about item B, we will stop there and go on to another item, and then we handle the technical matters and so on, and then eventually we come back to these items. And I expect by then it would be October. So we try to deal with the easier matters first, and then by then we can base our discussion on whether the government has successfully lobbied some of the bodies, and then members might feel that the administration will not withdraw its provisions on the controversial issues. Then members can submit CSAs, committee stage amendments. So I think it's not a good approach to stop the meetings right now. I think we can begin the clause-by-clause scrutiny. That would be relatively more simple, and otherwise we would be at a standstill. And the difficulty is that the council meetings are more in priority. If it's going to be a meeting next Tuesday, I'm sorry, I won't be able to attend. Because that afternoon we have two meetings in the afternoon, one of the Committee on Housing and so on. So we have to move between meetings, and that is difficult. Now, and just now we only had one member at the beginning, and that's me. So, and would that be a healthy way to conduct a meeting? And I think it's a bit too early to go into clause-by-clause scrutiny, because I have still some questions to ask. Maybe I get the same answers, but still I like to get the answers. For instance, the fine after a prosecution, the fee for the examinations. So I think it would not be fair to proceed so quickly. Now, Dr. Fernando Cheung had to leave just now to attend to some matter probably, and I think he may have questions. So I think it's too early to go into clause-by-clause scrutiny. My proposal was on the assumption that there are no other questions. Well, maybe all it takes is 10 minutes more, but let's not go into clause-by-clause scrutiny so quickly. let me reiterate. My suggestion is on the assumption that members have no further questions. If next time we have questions to ask, then we would not go into clause-by-clause scrutiny. Well, maybe at some point at the next meeting we will go into clause-by-clause scrutiny. Well, my duty is to have a thorough scrutiny, but members will certainly have the opportunity to ask questions. Well, I understand the difficulty of Mr. Cheung Kwok Chi. We may not be able to have meetings on Thursdays and Fridays because that would be taken up by the council. And then a lot of meetings are already scheduled for Monday and Tuesday already. Of course, we cannot have a meeting on the rooftop. No, so that's my proposal. Since it's so difficult, you can see that there were very few members just now. Some members were invited to attend other meetings in order to form a quorum. So if this goes on, the meetings would not be healthy. This would be too forced. Cheung Kwok Chi, I want to ask whether we can have a meeting next week. Now, if we want to go to the House Committee on the 20th, at least we need 2 more meetings before the 20th. So I feel this is most difficult. If we don't go for 20th, that is, we give up July, then we would have more meetings. I believe we can have meetings in July. There would be more members. And if we're going to have no meetings in July, then we would need to warm up before a meeting in October. So if we don't shoot for 20th of June, then we can have meetings in late June and early July. We can have 1 or 2 more meetings, and then after the summer we can go for clause-by-clause scrutiny. My assumption is that members have no further questions and would be ready for clause-by-clause scrutiny. But if you feel that on certain topics there should be more discussion, then I don't think we need to put the matter to the council right away. Now, of course, if members cannot attend the meeting, there can be a meeting, then there's nothing we can do. We need to have members, we need to have rooms available. So in principle, if we all agree, we would continue in our meetings. We would try to arrange for a date. We can ask questions at that meeting, and the administration can tell us how they discussed with the trade, and then we can begin clause-by-clause scrutiny. But if at that time there are not many members available, or if there are controversial issues like one of the 6 items at a certain clause, then we can have further discussion and members can submit CSAs. We understand. I don't think we need to do anything just to let the bill pass before October. I just think we need to conduct ourselves so that we can be accountable to the council. Now, we received some information from some patients' bodies. Now, the bill is a result of the drug incidents. We want to plug some loopholes, and we try to look forward because some drugs, especially cancer drugs, the process is to be streamlined. So instead of positive vetting, there will be negative vetting for the cancer drugs. The time would be shortened by half a year by our estimation. So some patient bodies, especially the cancer patient bodies, ask us to expedite. Now, of course, we respect members' views. If you have any question at all, we would be glad to explain. Now, on law enforcement, we checked for testing of each drug. On each test, it would be $1,200. So that's the answer for Mr. Leung. Now, we also have these requests from the patient bodies to expedite, and the patients may have to wait 6 or 7 months for the drugs just because the matter cannot be handled before the summer. Now it's a political decision on passing the bill, but I am not concerned with this political decision. We want to have a proper legislative process now. So I would continue to try to arrange for a meeting if members are available. But of course, we might end up with just one member, and we cannot continue. Then I would exercise my power to stop the meeting before, so we need not go into the clause-by-clause scrutiny. So that's my obligation. I have to follow the right process. So we will end our meeting a little bit ahead of schedule. I propose AM June 17th for the next meeting. If that's not available, well, I'm going to have a meeting in July. That's not a problem with me, but all meetings have to end by 30th of July. Well, if members say we're not going to have a meeting in July, well, so be it. I can't make it on the 17th. Now, we propose morning of 17th, but if the Secretariat circulates the date and many are not available, then we can try another date. Now, I don't quite agree with what has been said. Some want to be fast, some want to be slow. Well, we neither want to be fast nor slow. We want to follow the proper procedures. I'm not trying to pass judgment here. So if there are no questions, then we will end our meeting here. Thank you.